the mystery of indirect DNA transfer. I don't know whether we're going to answer the question of indirect DNA transfer unequivocally, but we'll certainly hope to discuss some areas around how we interpret DNA results and how we evaluate them in a forensic context. Okay, so I don't know whether these are fun facts at all, but I thought it might be worth just quickly running through the type of DNA analysis that we use routinely in forensic science. We use a test called DNA 17, and it supersedes the previous test, which was SGM+. It's more sensitive, so it has the capacity to generate profiles from very little material. It's optimized, the test itself, for recovery of DNA from less than 100 cells. So in real terms, that's actually not very much. But even then, it can generate what we would call good, usable DNA profiles from just a few cells. To try and give you a kind of a basis to understand how much DNA we need in order to generate a profile, then I've said there that it needs about 400 to 500 picograms of DNA. And you're probably thinking, well, what the heck's a picogram? Well, I'm going to try and help you there by saying it's a trillionth of a gram. So I'm sure that's exceptionally helpful. But in a cell, there are 6 picograms roughly of DNA. So you can see how we can start to do the maths and understand how many cells we need. SGM+, its predecessor, was optimized for about 1,000 picograms of DNA. So it's like twice as sensitive, really. And because of that, it means that we can generate profiles from material that previously would have failed in the test. And that adds its own complications, really, because it means that at this level of sensitivity, then we have to be really mindful of introducing inadvertent contamination, either through our handling of an item or through when we sample an item and when we process an item or an exhibit. And although we don't go out and intend to contaminate, then it's always something that we need to actively manage in the process. Because it's so sensitive, then for our purposes tonight, then it has implications in determining how and when any DNA that we detect was deposited. And of course, that drives to the questions around whether or not the DNA got there directly because someone handled an item, for example, or indirectly, which means it transferred there through some other intermediate. So if we ask how did that get there, then I suppose the basis of this is that in any environment where there is a source of DNA, then there's the potential for that DNA to transfer to other surfaces. I mean, it's pretty safe to say that's not infinite, but it's going to depend on lots of different variables, including how much DNA is there in the first place. And so depending on the conditions, depending on the environment, depending on the activities of individuals, then there might be routes for DNA to transfer without the original person, the donor of that DNA, necessarily knowing about where their DNA is transferred subsequently. And that's the issue that we're here to discuss this evening. If I touch something, if I handle something, if I have a direct association with an item or a surface, then we typically call that direct transfer. Anything beyond that is called indirect transfer, and you might hear terms of secondary transfer or tertiary transfer, but these are all indirect methodologies to transfer DNA from the original donor to other surfaces. So the million-dollar question, of course, and I can hear you shouting it down your microphones, is, well, can scientists ever say how or when DNA could have been deposited? And in a typically scientific answer, I'm going to say, well, it depends. So what are the things that help us to perhaps move towards giving an opinion on how DNA was deposited? Well, one of the main factors is whether or not we're dealing with a body fluid. If we identify something like blood or semen or saliva, and we're dealing with this tangible material, then we can oftentimes offer up an opinion about how it got there. The next question we need to ask, well, can we be confident? Is there a scientific confidence that the sample is pure and hasn't been mixed with other sources of DNA? When we get mixtures of DNA, it becomes a little bit more complicated. And when I say little, it could be exceptionally difficult. So we need to be really mindful of how we deal with mixtures of DNA. The other question we ask is, do we have a good full DNA profile? And by good, I use that kind of loosely, but it means, is the profile sufficiently defined that it's strongly represented, there's no ambiguity around it, and we can say that it's a full complement of information that we would need to see? Or sometimes we might call that a major contribution of DNA. There's a prominent contributor of material to a sample, which means that anybody else that might have contributed DNA is sufficiently low level that it hasn't affected the interpretation of the main profile. And if in those circumstances, then there's a possibility that we might be able to what we call attribute that good profile, that full profile, that major profile to the body fluid that we detected and that we analysed in the DNA analysis. I'm going to talk about attribution in a second, because if we can attribute the DNA to a particular material, blood, semen, etc., then it means that then we can move our focus to talking about what that body fluid means in the context of the case circumstances. So what is attribution? Well, you probably know this, but attribution of DNA is an area where we have some confidence that the DNA came from or originated from the thing that we found, the blood, the semen, the saliva. In these cases, we need a good representation of DNA within the result in order to be able to sort of link that part of the result back to the source body fluid. And if we can do that with any certainty, as much as scientists can be certain, then we might say that, in our opinion, the DNA originated from the thing that was tested, from blood, from semen, etc. So attribution is almost like the first point. And if we can't attribute, then we really do need to step back and try and understand whether we can actually give an opinion on how that DNA could have got there. Now, in terms of transfer of DNA, and by this I mean not DNA that can be attributed to a body fluid, but just, you know, DNA, just bog standard, not linked to any body fluid type of DNA, then there is a real growing body of research around it. So it means that, you know, there's been a lot of very, very clever people have tried to understand mechanisms by which DNA can transfer. And they've specifically defined a situation that we might encounter in casework in order to try and provide some empirical data on which we can sort of firm up any interpretation. Now, the problem here is that it's very difficult to simulate all casework scenarios such that you can apply wholeheartedly the research to a casework situation. So, you know, there are infinite variables and infinite possibilities oftentimes in casework that we might not necessarily be able to robustly investigate through research. So because of that, it becomes really difficult to just link onto a research topic and say, right, that one applies here, and therefore the answer is indirect or direct. There's insufficient data really from experimentation of touch surfaces using the same sensitive DNA test, that's DNA 17, as the test that we use routinely in casework, to identify precisely how DNA transferred. And you could stop the talk there actually, because it means that we're never really going to be able to give an absolute concrete answer in terms of how DNA got there unless it's attributable to a body fluid. Some of these studies have demonstrated that the indirect transfer of DNA can outweigh DNA that has been deposited directly. And so that kind of throws a spanner in the works, because there's almost an assumption that it's a limiting return. So the more DNA you have, the more likely it is to have been transferred directly. But these studies demonstrate that that's not necessarily the case. And it's especially the case if we're talking about the indirect transfer of body fluids. So I've already said that if we can attribute the DNA to a body fluid, we move into an area of certainty. But the thing is, we don't always test for body fluids. So we might not know if a body fluid was actually there in the first place. And this means that if we don't know what was there in the first place, then how can we know whether or not a body fluid was in the sample when we took a swab of it, or we analysed it in any great detail? So that's something to look out for. If a full body fluid examination has not been carried out in a case, then you're kind of in a bit of a black hole, because you don't know what you were dealing from at the start. The other thing that this research has demonstrated is that the vector, so the thing transferring the DNA, whether that be a person or a surface, doesn't necessarily leave a trace of DNA itself. And this is particularly relevant when we're looking at whether or not someone else could have transferred DNA from an individual. It is not inevitable that they will leave their own DNA, and therefore not detecting their DNA doesn't mean they didn't transfer the DNA of another person. So it becomes exceptionally complicated. And I asked myself, you know, are the jury going to get this? Because it is a real tricky area. So let's look at DNA mixtures. Now, because of the sensitivity of DNA 17, it's almost inevitable that we're going to get a DNA mixture. And that's not for want of trying, because DNA mixtures are rubbish. You know, if at all possible, we would love to always generate full DNA profiles. You know, mixtures take time to interpret, they're time consuming, they're complicated, they make you scratch your head a lot. And so, you know, if we could avoid them, we would. But unfortunately, because the technology is advanced to where it is, DNA mixtures are almost always going to be generated in some form or another. Now, mixed DNA results, and this is DNA results which don't show a prominent contributor. They're kind of a soup of DNA from various number of contributors, rarely provide information to determine unequivocally how or in what order that DNA was deposited. I say rarely, and then in brackets I put never ? Because it's arguable that if you get a really sort of complex mixture, I'm not sure whether it could ever tell us how or in what order each element of that DNA was deposited on a surface. The other thing that we need to take account of is that the DNA, looking at a DNA result doesn't tell us what form the DNA took. So it doesn't tell us this is from blood, this is from semen, this is from cells, this is from saliva. It's just literally data, and it doesn't identify or have a flag on it that tells us the body fluid that was tested. So because of that, it makes interpretation or evaluation really complicated. It also doesn't tell us where DNA was on the surface when the sample was recovered. And this is particularly important when we have samples that have been combined for DNA analysis. Oftentimes, this is a strategic decision. It might be to reduce the number of tests that have been done, possibly to reduce budgets. And if we've got samples that are combined from various areas on an item, such as a firearm, then it means that any DNA detected, we don't know precisely where it was originally. And that might be important because we might be looking at the distribution of DNA and trying to use that in some substantive way. Taken in combination, it means that we can rarely provide definitive interpretations. And you're probably thinking, well, why the heck do we bother calling a forensic scientist? You know, and quite honestly, you know, I wonder that too sometimes. But I think it's really important to put it into context, the DNA, and whether it means anything or whether it actually is so complicated that you should cast it aside and not rely on it. If an individual's reference DNA profile has been compared to a mixed DNA result and there is no statistical evaluation of that potential match, the result must be considered evidentially inconclusive. Now, I'll leave that sentence with you for a second, because it means that if a scientist says there are similarities in that result to the profile of your client, without a statistical evaluation to back up that comment, the comment in itself is meaningless. Without statistics, it is not possible to provide you with a level of understanding as to whether or not that individual may or may not have contributed DNA. And the Forensic Science Regulator has published guidance on this. It's in the mixture interpretation document. I can provide you with a reference. I'll probably put it in the chat later. But guideline 15 says that qualitative evaluations should only be presented as investigative opinions. That means intelligence. It's kind of a look-see, but it's not an evidential opinion. It's not an evaluation, and it can't be used evidentially in court. This means that this should not be conveyed in a way that the investigator could consider that they have evidential weight. This can only be determined if a statistical calculation, and that includes this specialist stuff, the specialist statistical calculations that we can now do using LIRA and STR mix, etc. Without that probabilistic approach statistically to the evaluation of a mixture, if someone says this person could have contributed, that comment is utterly meaningless, evidentially. Now, you may have had cases in the past which were based on Pickering and Douglas, in which a qualitative DNA opinion was provided to the court based on my experience and my understanding and my knowledge, etc. In my opinion, this person could be considered as a contributor of DNA without backing it up with statistics. This practice is no longer supported. And so you mustn't accept that. You must ask, can I get a statistical evaluation of this result, including using specialist statistics, which are now widely accepted? And if the answer is no, you must put that result to one side or ask if other techniques can be applied to it to provide evidential information from it. Now, of course, when we provide opinion, that is forensic scientists, then we can provide various types of opinion. Investigative opinion, which is typically the stuff that happens before we get to court. So I'm going to focus on evaluative opinion. And evaluative opinion is when we weigh up the evidence on the back of two sides of the coin, the prosecution and the defense alternative. Now, there are pros and cons to evaluation, and of course, this is a talk in itself, but we use our expertise to help others answer questions, and by others, usually the jury or the court. You know, we're not here to say somebody is guilty or not guilty, but we can provide you with a guide as to whether or not the scientific evidence has any weight or not. The best way, the most robust way, of course, is to evaluate the scientific findings against a framework of competing propositions, given the case information that's provided. Now, the cons are that we might not have enough information to robustly consider those propositions. We might have too much information, we might be saturated with it. And of course, contextual bias and the bias of information is something that we need to manage in this process. We need to take real care when we're dealing with no comment cases, because it means that we don't have the alternative against which to balance our opinion in relation to the prosecution allegation. And this is where we can come unstuck a little bit. So when you're reading your reports, whether they be short formats or abbreviated or full witness statements, then ask yourself, does the report include an evaluation of the DNA findings in context with the case circumstances? This is really important. If not, ask that that's done. Get in contact with the scientist and say, right, hang on a sec, can you please progress an evaluation of this? Otherwise, it's open to a misapprehension about what the DNA could mean. If it has been evaluated, then check, has it been evaluated against the prosecution and the defense alternative? And if it hasn't, then ask yourself, do I know what the scientist is going to say if they're asked to consider a defense scenario? Because at this point, you might have had a report that says, well, the DNA could be explained if they touched the gun as alleged, or they handled the knife as alleged. And if you haven't had a kind of a window on what the scientist might say if a defense alternative is provided, then you're unsighted. And it could be that they say, well, actually, the findings are equally likely given both alternatives, so therefore it's neutral. And you probably don't want to be in that position when you're in evidence in chief, I would think. So, for example, do you recognize any of these phrases? The presence of DNA matching whoever indicates that some form of DNA transfer has occurred. This could include him having touched the firearm. The DNA findings are in keeping with someone having had contact with the inside of the pocket as alleged. But there could be other explanations, and if that person provides an alternative, the findings could be evaluated later or further. And this puts you in a difficult position, because at the end of the day, you're not really, it's very difficult to understand how that further evaluation could change the strength of the findings. I just want to really quickly go through a very brief case example. This was a case where a woman was attacked by a group of individuals, and her handbag was snatched and her coat was ripped during that struggle. And the SFR, the Streamlined Forensic Report, outlined some really interesting information. It demonstrated that, first of all, cellular material had been recovered from the area that would have been grabbed in order to rip the coat. It told us that a full DNA profile had been obtained. They'd used the technology DNA 17, so we know about that now. And it seems a good result. I mean, it matched an identified male who I've called male 1. So that person was nominated, ultimately taken to trial, and the match probability was 1 in a billion. Now that's the gold standard match in the UK. So it all sounds pretty tickety-boo, really, in terms of its evidential strength. The problem is that it was an SFR, and until trial, a full witness report wasn't commissioned. Now, when that full witness statement was presented, it read like this: a mixed DNA result indicating the presence of DNA from at least 6 individuals. So it wasn't a DNA profile that was just simple, good, full profile. It was actually a very complex mixture. It included at least 1 male, that's because of the presence of a Y chromosome, and at least 1 female, that could be the wearer. There was no clear major, and because of its complexity, the finding was not suitable for statistical analysis. So the 1 in a billion was an error. It was not reflective of the result, and the CPS offered no evidence in that case. So it just demonstrates that SFRs really do need to be challenged, and I would strongly advise that you do that if that's something that you are taking a case to court on the back of. Okay, so at that stage, I'm going to stop talking, actually, and Fran and I are going to, I think, enter into a little bit of a Q&A session.
Yeah. Oh, I'm working again. Hi there, Joe, thanks so much for that. That's absolutely great. I think the problem is with so much information, which is also useful, there's just too many questions and we could probably be here. So what I'm going to do is just try and focus really on cases involving DNA where it's found on a movable object, for example, drugs packaging, or on a gun, something like that, just to try and narrow it down a little bit, because I'm sure, other than my questions, I'm sure there'll be lots of people with others once we've finished. I'm going to go on in a little bit to look at some of the case law on transfer. But I just want to ask you, please, about what you were telling us about the no comment cases, where there's no alternative explanation for transfer. And you were saying on the face of it, that can look as if it strengthens the prosecution's case. And I think as defence practitioners, we might often be presented with a report that simply confirms the presence of the defendant's DNA, well, DNA matching the defendant. It might go on to tell us that that's in keeping with the defendant having touched the item, but there might be an alternative explanation if the defendant provides an alternative explanation, and those findings could be evaluated further. And I think that when we get such reports, it's quite tempting for a defendant at that stage to come up with an explanation, so the scientists can look at that. Are there good explanations and bad explanations that you look at when you're trying to evaluate maybe a no comment interview and a defence statement after?
I suppose in short there are, but the question is, if you've got a really complicated mixture, it's very difficult without any alternative at all, in fact, saying how that DNA got there. So if you speak to a client and say, well, can you explain it? I just wonder whether or not that's a reasonable question, because, you know, I'm not certain that they're sufficiently voiced in the complexities of DNA transfer to actually answer, well, how did it get there? I mean, do you know where your DNA is? I certainly don't know where my DNA is. And I just wonder whether or not it's a reasonable question to be asking, when in fact, in isolation, the DNA result in itself does not help us to identify the specific route. So even if they propose something, how do we understand whether that's the answer, or whether there is another alternative explanation that that person hasn't suggested, and that's the answer? It's just very difficult to kind of prioritize them because the result is so limited in itself.
might they put up an answer that really then can just be knocked down by the scientists to say no?
Precisely, and it might, you know, and it might, that's exactly it. It could encourage a really convoluted explanation, because in their mind that's the only thing that they can think up that could explain it. But that doesn't mean that that was it.
Yeah.
It could be another perfectly reasonable explanation that just we don't know about because we weren't there at the time, or we don't know the full raft of possible explanations.
So unless you got, say, an explanation that was pretty cogent and that can, you know, was backed up. I know you and I were chatting about a case I was involved in a couple of weeks ago, where the issue was transfer, possibly direct, possibly secondary transfer, where the defendant in 2014 was in the barber's shop, was attacked by somebody, struck on the head with a gun, and then the police found the attacker, never found the gun. And all these years later, 6 years later, guns recovered and his DNA's on it. And in that case, he said, well, yeah, I was attacked a few years back with a gun. I've never touched any other gun. And you've got the police records, you know, it's all over the Echo. And that was looked into. Is that the type of a decent explanation that you might say, well, yeah, that's helpful?
Yeah, of course. I mean, you know, there's a legitimate reason. If that's the gun, then that's a reason for their DNA being on there. Then absolutely. And of course, as I was saying, it's not always the case that those areas that are swabbed will be tested for blood before the swab. So it's possible that blood was there and it wasn't detected, or it wasn't, you know, looked for. So how could we discount that as a reasonable explanation? And in that case, it would be evaluated as such.
In fact, they dropped the case a couple of days ago. But looking back at what we were saying about providing an alternative explanation, and the temptation, I think, is by defendants to see that in a report and then to, you know, try and come up, you know, with an explanation. And obviously, in a criminal case, it's not for the defendant to prove their innocence. It's obviously for the Crown to make the jury sure. So what you might end up with is the experts saying, well, you know, there are two possibilities here. One is that he's touched it, and another is that it hasn't touched it and it's by indirect transfer. And without that alternative explanation, where does that leave you then in saying which is more likely?
Well, you can't, can you, really? Because you know, I mean, to say it could be because he handled it is almost really unhelpful in that situation, because there is no way to balance up that alternative. So I think we need to relook at how we evaluate these types of results in a forensic context, because otherwise it seems like we're supporting the prosecution allegation, and in fact, I'm not sure there is a basis on which to do that.
It is the reality without any alternative explanation. So in the no comment cases, you're simply not able to say which is more likely, indirect or direct transfer.
Yeah, that's the way to go. I always say, you know, everybody knows where their mobile phone is, right? You know, if you lose your mobile phone, you're looking for, you're going to utter panic, you know. But do you know where your DNA is? No, not probably. Do you know where your children are?
In the room eating.
You know, so it's like, how do you keep tabs on something that you can't see? Yeah. It's impossible. It really is.
So you can't say which is more likely, direct or indirect, and I think that's right, isn't it? Even if a full profile is obtained.
If the profile can't be attributed to a body fluid, you know, if you've got DNA that's from semen or blood, then you can talk about semen and blood. But if it's DNA, just ethereal DNA, then it can be very difficult.
And even, for example, if the DNA is on 2 items or 3 items, you can't say.
It doesn't necessarily mean that if you get more of it, it doesn't mean that therefore it must be direct transfer, because there are so many variables that we don't know about, that we would need to define in order to give a definitive answer.
I think one of the things you were saying that was really helpful is that in reality, because we don't know where our DNA is, I'm sure ours is all over the house at the moment, it's just not really realistic for a defendant to be able to say how his DNA got there. And
precisely.
So,
I think that's the case. Yeah, absolutely.
Yeah, brilliant. Oh, cheers, Joe. That's really helpful. Well, I see that time's pressing on. I've got a few slides to go through. I hope I'm not teaching anybody to suck eggs. I'm sure most people are familiar with all the case law, so I'll try not to bore you all for too long about it. Joe's kindly helping out with the slides here. Hopefully this will all go right. She knows what she's doing and I haven't got a clue, basically. First of all, I just want to give you a brief run through of the lead cases, really regarding where DNA is the sole or decisive evidence in a case, and the courts have been looking at transfer. So these are the three main cases. F&C in 2016, sariki, I can never say it, which came a year later, and then William Jones, which was a very recent decision by the Court of Appeal, and is a very helpful one when we're considering a movable item where DNA has been deposited on it, which is kind of where we're focusing this talk tonight. Sakiri is considered to be the leading authority, and that case has quite a helpful checklist in it as regards some of the issues that the court will need to consider. So we'll come to that in a bit, but firstly, just want to tell you a little bit about the case of F&C, which is our next slide. In that case, that there was quite a helpful review of all the previous rulings and the DNA authorities, because they've been going back quite some time, and obviously the science has made great progress in the last few years, and that was one of the things that the court focused on. F&C was an appeal by the Crown against a terminatory ruling. A bit of an interesting case. A poor complainant was on the tube one night and felt a man bumping into her repeatedly. Didn't really know what was going on, but unfortunately, and probably rather unpleasantly, at one point felt something warm through her trousers. And it was only once he got off the tube that she realised that he'd ejaculated over her. And so, of course, there was a DNA match. In this case, the DNA match was a very high DNA match to the defendant, who wasn't picked up till about 10 years later. And they noted that obviously in this case, the court decided that where there was a very high DNA match, as there was in this case, from semen, and the important bit is that was deposited clearly during the commission of the offence itself, then even without any supporting evidence, no Viper or anything like that, then that really did call for a case to answer, even when there was no supporting evidence. So I suppose the important point of F&C is that the DNA was clearly deposited during the course of the offence. And so that case did call for a case to answer. That case was considered in Sakiri, which is now really considered to be the leading authority on DNA and transfer. In this case, the complainant got in her car, and once she had done, the offender grabbed hold of the car handle, opened the door and robbed her of a necklace. Again, in that particular case, there was a DNA of a high match at 1 billion. And that was recovered from the door handle where the offender had opened the door. Now, in that case, the court heard expert evidence of the type that we haven't been discussing here, but went as far to say that secondary transfer in that case was improbable. Secondary transfer was unlikely to be an explanation for the presence of the defendant's DNA at the scene. So in F&C, the court held that because there was a high match DNA profile left on an article at the scene, of course, the car handle, again, that can, without more supporting evidence, give rise to a case to answer. So again, the real issue there was the fact that the DNA was deposited during the course of the offence itself. And so I think that can be distinguished between the movable objects cases that we'll come to in a bit. But in any DNA transfer case, whether direct or indirect, you need to really be looking at sariki, because what sariki did was to hold out a real checklist for the court to look at when deciding these cases. It's not an exhaustive checklist, and that's one of the things that the court said. But helpfully, you'll get these authorities in an email over the course of the next 24 hours or so if they've not been provided already. But it's paragraph 15 of Sariki's judgments that you'll all have access to. And so some of the things that we wanted to know was whether there was any evidence of another plausible explanation for the presence of the defendant's DNA on the item other than involvement in the crime itself. Importantly, the court said that the absence of any explanation of itself wouldn't provide additional support for the Crown's case. So that's important in the no comment cases that Joe has been talking about already. Importantly, on that point, in looking at any half-time submission, or even if the case went further, the court was saying that a section 34 direction is going to be unlikely in any DNA case of this type. And that's something that originally had been discussed by the court in F&C. So that's also always something to be bearing in mind. But the court also asked, was the article apparently associated with the offence itself? Of course, if we've already been looking at it, in this case, the DNA was on the door handle of the car that had been touched by the offender, so absolutely had been in the commission of the offence. But the court went on to note that it would be a very different position if the article wasn't so connected with the offence itself. So, for example, if a cigarette butt was left at the scene of the crime with the DNA on, well, that may not be as probative as the door handle situation that we had in Sakiri. The court also said it'd be important to look at how readily movable the item was. So DNA on a movable item, again, might have less probative force, again, going back to the cigarette butt that we've just been talking about, but important in cases of drugs packaging and DNA on guns or a screwdriver or something of that nature. That's an important point to bear in mind. They also wanted to look at whether there was any geographical association between the offence itself and the offender. That can cut both ways, really. And so it was important in the case of Sakiri because the car was in one postcode. The defendant came from not far away, but that was something to look at. But geographical association can cut both ways and can be a red herring. And so it was looked later on in the case of William Jones that we'll come to. Just always think around the issues in relation to geography. They also thought that it'd be important to look at whether it was a case of a mixed profile, whether the defendant was a major contributor. Now, again, this was a case that was 2017, and I'm sure Joe will explain things have been moving swiftly in relation to the science on this point and secondary transfer. So when you're looking at this issue, what was the defendant a major contributor to a profile? You might want to be looking at instructing somebody like Joe to have a look at this point, to consider secondary transfer, because an expert may say, well, so what if it's a major contributor? It still doesn't rule out the possibility of secondary transfer. One of the other things in the checklist, was it more or less likely that the DNA was deposited by direct or indirect transfer, which we've just been looking at. Now, in Sakiri, again, can't say it, the expert position was that secondary transfer was improbable. And that's quite a lot for experts to go that far. And so, importantly, the court said that each case is going to turn on its own facts. And so the list isn't exhaustive. So one of the things that we wanted to really look at was this issue about movable objects, because it's so important and it seems to turn up in so many cases. There's been an important authority quite recently. It's only been out about 3 or 4 months, the case of William Jones, which a lovely host tonight, Sarah Day, and I were involved in at first instance. Not for Mr. Jones, unfortunately, but here in this case, again, there was a high level of DNA, and that was matched to the defendant, William Jones. His DNA in that case was found on the firing pin of a hand grenade that had been left under the car of somebody who was said to be a rival OCG member. It seemed, as the evidence unfolded during the case, that the offender just simply hadn't pulled the pin out correctly, and the DNA was right on that firing pin. Again, we had a no comment interview. Mr. Jones made no comment. The only thing he did say was to simply deny ever handling a grenade, and that was it. There was expert evidence called by the Crown, and there was a set of agreed facts between the prosecution expert and the defence expert. But the agreed expert position in Mr. Jones's case was that the evidence was within the range of expectation that the defendant had had contact with the pin or of the grenade, which might sound quite forceful on the face of it. But they also went on to make a number of very helpful points. And when you get the judgment and you have a look at it, if you go to paragraph 10, have a read of what the experts agreed, because it's quite helpful when you're instructing an expert to have those things in mind. If you're putting it in your letter of instruction, or you're putting it in advice to your instructing solicitors, to go to those points, or even pop them into your advice for things for the expert to look at. One of the things that they did agree in that particular case, which the Court of Appeal held on to, was the fact that they agreed, as Joe's been telling you, that it's simply not realistic to expect anyone to account for how their DNA may have found its way onto an item by indirect methods. The court were really stuck with that scenario, and of course had to quash the conviction ultimately. The court did, however, comment, unfortunately, that perhaps the expert shouldn't have made such a broad admission, and that it was unwise. And it seems that forensic experts have now got onto that paragraph in the judgment and are quite reluctant, understandably, to go that far. But it can be that when you're cross-examining an expert, they will make that concession, especially if you don't quite phrase it in that way, because it's common sense. Just as Joe has been telling you, our DNA is probably all over the house, and I wouldn't know where it is because, of course, it's not lit up with LED lights. But have a look at those agreed facts, because they were really important. So the ruling in Jones was obviously considering a movable object. They considered all the points in sariki. And in relation to geographical association or connection, which I was erring on the side of caution with before, they looked at that and they thought that, well, actually, it didn't really help them. This offence occurred in Warrington. Mr. Jones lived in Warrington, only up the road, really, from where the grenade had been thrown. Now, the judge at first instance found that to be quite compelling evidence and hung his hat on that in dismissing the submission of no case to answer. But the Court of Appeal didn't agree with him and said, really, it doesn't assist here. If, for example, Mr. Jones had lived in Scotland and his DNA had been on the grenade in Warrington, then it may have meant that secondary transfer was less likely. But perhaps here, the geographical proximity of his home address to where the grenade was found really meant there was more of an opportunity for innocent contact, perhaps with meeting a conspirator on the street and an innocent handshake before that person went on to touch the grenade. So their geography really couldn't add any support to the prosecution's case. So from the expert evidence, the height of it was really that there was no conclusion that could be reached regarding the likelihood of transfer. They had the general proposition, of course, that direct transfer is more likely than indirect transfer, but of course both are possible, and really, as the prosecutor accepted at the Court of Appeal, that was the height of the prosecution's case ultimately against Mr. Jones. But the court found that probability just wasn't enough, of course, for a finding of guilt, and you may think nor should it be. They again agreed that the case couldn't be bolstered or supported by a Section 34 direction. And on the back of that, the conviction was quashed, and and he was a happy man. So just want to move on before we wrap up, well, start to wrap up anyway, in relation to a case study, just when thinking about trial preparation, etc. This is a case that I was involved in quite recently, about 4 or 5 weeks ago, following, helpfully, the decision in Jones, where again, the defendant gave a no comment interview. There were 4 areas, as you can see, of his DNA, high level, billion match, again, of a mixed profile. And his DNA hits were found, 2 DNA hits, different areas on a Glock, another hit on an Arenco, and 1 hit on the box that the firearms were found in. Now, those firearms were found hidden in a sea container close to the defendant's address, about 150 metres away. Again, you see, no comment interview. And despite having the type of report that we were talking about, saying, well, one possibility is direct transfer, another possibility indirect, we can't say which is more likely without an alternative explanation. He didn't provide an alternative explanation in that case. So the Crown's expert was left with simply saying she can't say which is more likely, direct transfer or indirect transfer, unless she's provided with that explanation. So the judge in that case tried to shore it up, I suppose, for the prosecution, by asking her, well, would it not make a difference, the fact that here we've got a defendant with 4 different DNA hits on 3 different items? And very fairly, the Crown's expert said, no, it won't make a difference at all. She said, without that explanation being provided, an alternative, I simply can't evaluate it to say which is more likely than the other. So effectively, the Crown's evidence was neutral in relation to DNA. And considering Jones, the judge found that the fact that they were only 150 metres away from the defendant's home address didn't provide any extra support for the Crown's case, because again, the issues that the court were looking at in the case of Jones, plenty of opportunity for innocent transfer onto another surface or via another person as a vector. Again, no Section 34 direction. And I'm sure you're aware of the case of the Crown and Smith, where you can't simply draw an inference, an adverse inference, where there's simply been a bare denial and no positive alternative put forward. So given the judge found that the evidence was at best neutral as to how the DNA had been deposited on the guns, with no supporting evidence, the case was stopped at half-time. Moving on, I've included here a couple of checklists, really. I've included one for the prosecution because I can see on the list of people that have attended that might be beneficial to some of you. And I put this on really because at the end of the case that we were just talking about, that I was involved in a couple of weeks ago, the judge, once the court had been cleared, really made a few observations. And one of the things that he said is, following the case of Jones, you know, the prosecution really need to be thinking about these cases from a very early stage. Some joined up thinking between the expert, prosecution counsel, the CPS and the police. Because given the recent case law, you know, that this is going to be happening more and more, you know, cases where there isn't supporting evidence, they're just going to be stopped and kicked at half-time. So real consideration needs to be given by the Crown at a very early stage as to whether or not there exist realistic prospects of convictions in such a case. So that's important if you're prosecuting. If you're defending, that's important to know, because that might help you to try and put some pressure on the prosecution from an early stage, or certainly from when you get your report and are in a position to serve it, to try and put some pressure on the Crown to drop the case. In terms of defence checklists and running a case that we put such of the type we've been talking about with a movable object, really, or DNA transfer generally, saying the obvious really, but you need to be looking at from the off. You know, what are the facts of the case? These are the facts of the case, a little bit like F&C, or you know, do they call for an explanation, or don't they? If it's on a movable object and the defendant hasn't got an explanation, then you know, obviously be looking to a no comment interview. If bare denial, if you want a bare denial, but a no comment interview, because it's not going to hurt down the line. The judge isn't going to be able to rely on that in terms of any adverse inference at trial, even if the defendant were ultimately to give evidence, and we were looking at a section 35 direction, as long as they weren't putting forward a positive case and simply denying the offence, then there should be no adverse inference. So thinking about no comment interviews from the start. Then one of the things, of course, you'll want to be doing is looking to instruct an expert to comment on the possibility of indirect transfer, and trying to get a joint report where the evidence ultimately ends up being neutral, or as neutral as you can make it. Like we've been saying, one possibility is that they touched it, another possibility is that they didn't touch it, and simply without an alternative explanation, we can't say which is more likely than the other. And that's really one of the best positions you're going to get in with such a case. And that, of course, gives you the opportunity to launch a submission of no case to answer. If that is unsuccessful and you've got to go all the way, then on the final slide, and I'm not going to read it all to you now, you'll probably be pleased to hear, I'll try to give you an idea of a suggestion for something to be included in a jury speech, or a speech to the magistrates court, or something of that nature, because I think it's important, like Joe was saying, it's really difficult for a jury to understand all this, because it is quite complicated. And when you've got a case, you know, say the grenade case, or guns, or something of that, or drugs, something of that nature, you know, it's not going to go down well with a jury. They don't like it from the off. You know, really the gut instinct is probably, you know, wanting to convict, especially in a case where you've got an enthusiastic firearms officer coming in with a submachine gun and wafting it around for them to see, or showing a video of a grenade being detonated. It's all pretty terrifying stuff. So really, I think, you know, one of the ways around this is to try and get them to put themselves in a position to appreciate that this frankly could happen to anybody, because we are depositing our DNA all over the place all of the time. And I think COVID's probably taught us some of that, and we're all a little bit more aware of it than we were before. You know, the juries will leave DNA in jury rooms, they'll deposit it all on the route to get to the court. So I've just included there for you to have a look at an example of trying to get the jury to put themselves into the position of recognising that frankly this could happen to anyone, and it could happen to them if they were so unfortunate. So just on the note of the handouts, Joe has been a technical whiz kid with all of this, doing all the fancy bits on the slides. I've given her the basic bod standard stuff, and she's made it look amazing. So thank you, Joe. What she's going to do tomorrow is make it look even more amazing. So I'm going to leave that in her hands. And once it's all ready and it's a souped up version, it will send it over to Chambers. And I know that they're going to email it out to everybody who's attended tonight, together with those authorities. And so hopefully you'll have everything that you can refer back to. But you've got our email addresses there. They're on the handouts that you will get emailed to you. So if you go away and you have a question that you don't ask tonight, that hasn't cropped up, or you haven't thought of, just get in touch with either of us. That's no problem at all. I'm sure we'll be happy to help. Joe knows more about it than I do, obviously. So yeah, I'm sure she's probably your woman. Okay. Well, thanks for that. I think if you want to ask some questions, Sarah's in control, and I'll hand over to her.
Thanks very much, and thanks. I think we've got 2 questions which have been put into the chat. I'll do my best with everybody's names. I do apologise in advance if I get them slightly wrong. So our first question, and I'll just try and unmute you now, is from Angarad Moosley. Or if you'd like to ask your question, have I managed to unmute you?
I think it's already been answered, in fact, by Denise Indercombe Court. The question was simply, does the presence of a full DNA profile make it more or less likely that there'd been an indirect transfer? And she sensibly said it depends on the primary source, which you don't know. So it really underlines the point that if it can come in a kind of full Technicolor version, is that right? And you still may not know where it's come from.
Absolutely. I was just checking Denise's answer just to make sure I agree. Hi, Denise. I have to agree because it's Denise. So 100%. I mean, you don't know what you're dealing with at the very start, do you? So how can you make a determination as to whether or not you would expect a full DNA profile and whether that's any more probative than an incomplete profile? Because you don't know what the starting position is. Yeah, absolutely.
Okay, thanks.
All right, and on that note, I think we also have a question from Denise, in fact.
No. Uh-oh.
Well, it was just, I don't know if you can hear me, but it's just about,
yeah,
you know, most of the evidence, it seems, can be, regarding DNA, can be undermined. So how often is DNA evidence likely to be useful in a case from a prosecution point of view?
Fran?
I think probably in those cases like Joe was talking about, when you can link it to a bodily fluid. So maybe, you know, if semen was found in a complainant's knickers, you know, then I think that's pretty compelling evidence as to direct transfer and where it would be helpful. I think when it can't be linked to a bodily fluid, and I'll say, I'm sure Joe will tell me if I'm saying the wrong thing, but I think if it can't be linked to a bodily fluid and it could, you know, just be there by secondary transfer, then I don't think it's really, you know, that helpful at all, unless there is some surrounding, you know, some supporting evidence. So, for example, you know, in the lady that was robbed while she was in a car, there was the DNA evidence on the handle. If she'd gone on, if she got a look at him, she was able to give a description. But in that case, it could have matched half of London. But I think if she'd have gone on to be able to pick him out on an identity parade, then DNA evidence would be useful, because not only she picked him out, but then bang on, his DNA's there. So then, you know, it's the nail in the coffin, I think.
I mean, the other thing we didn't talk about, Denise, though, but about the way in which you use DNA for intelligence, isn't it? So, I mean, if you have a no suspect attack and you generate a profile which you can link to the database and generate some intelligence, then of course it's extremely powerful, isn't it, on that level? But then you need to add on other things that help to understand if there is a case to answer at court. So it depends. It's a really good tool to kind of narrow an investigation in some cases, but of course, when you evaluate it, it could be utterly meaningless.
All right, great. I think that's all the questions that we have in the chat. So with all of our thanks to Fran and also to Joe, I think we will end things there. Thank you both very much.